The rule was again restated in Edward versus Halliwell 1950 to Ollier 1064, wherein Lord Justice Jenkins observed, the rule in Foss versus Harbottle comes to no more than this. First, the proper plaintiff in respect of a wrong alleged to be done to a company is prima facie the company itself. Secondly, where the alleged wrong is a transaction which might be made binding on the company by a simple majority of members, no individual member of the company is allowed to maintain an action in respect of that matter, for the simple reason that if a mere majority of the members of the company is in favor of what has been done, then cadet quaestio. If on the other hand a simple majority of members of the company is not against what has been done, then there is no valid reason why the company itself should sue. In Rajamundry Electricity Supply Company versus Nageshwar Rao, AER 1956, Supreme Court 213, it was observed that the courts will not in general intervene at the instance of shareholders in the matters of internal administration and will not interfere with the management of the company by its directors so long as they are acting within the powers conferred on them under articles of the company. Moreover, if the directors are supported by the majority shareholders in what they do, the minority shareholders can in general do nothing about it. However, in ICICI versus Parsuram Synthetics Limited 1998-92 Company Cases 238, it was held that the rule in Foss versus Harbottle cannot be applied mechanically in India. In this case, it was observed that financial institutions provide huge finances to the company, though their shareholding may be small. In such cases, they cannot be rendered voiceless in respect of company affairs. Application of principle versus Foss versus Harbottle would be unjust and impracticable in such cases. In Bakery Cereals versus Hanuman Prasad Bargi 2001 105 Company Cases 465 Calcutta High Court Division Bench, history of Foss versus Harbottle was traced. It was observed that this rule prevailed in India from 1843 to 1956. Protection to minority against oppression was provided for the first time in Companies Act in 1956. In England, law has been radically changed in 1980. Now, the minority need not prove oppression. They only have to show unfair prejudice, but not so in India. If company suffers losses on account of working, the directors cannot be held responsible if they have acted bona fide in the interest of the company. They cannot be punished for wrong business decisions due to which company might have suffered. However, if a damage or injury is caused to the company by fraudulent acts of the directors, they can be held responsible. Even in such cases, the company is the injured party and not individual members. Thus, action, if any, can be brought only by the company and do not by individual members. This is based on the well-known legal principle that only a person aggrieved can be a party to the suit. He alone can sue or file an appeal. Others have no locus standi in the matter. However, this principle is likely to cause irreparable damage or injury to the company, as the majority shareholders can misuse their powers and use the company for their personal gains. It is well established that board of directors of members should take decisions which are in the interest of the companies and not of directors or any particular group of members. If the directors control majority, it is obvious that they control the company, and hence there is no possibility that the company will take action against such erring directors. The minority shareholders will be just helpless spectators while company property is being misused and company is being mismanaged for personal gains of persons having controlling shares. Exceptions to the rule in Foss versus Harbottle. The majority supremacy, however, does not prevail in all situations, but there are certain acts which no majority of shareholders can approve or affirm. In such cases, each and every shareholder may sue to enforce obligations owed to the company. He brings the actions as a representative of the corporate interest. There are, however, certain exceptions to the majority supremacy rule. It extends only to cases in which the company is competent to ratify its managerial acts. There are certain cases which no majority of shareholders can approve or affirm, and even a single shareholder can sue for enforcement of obligations owed to the company. He does so in the representative capacity of the company, and therefore the relief goes to the company. Wrongdoers in control. Sometimes an obvious wrong may have been done to the company, but the controlling shareholders would not permit an action to be brought against the wrongdoer. In such cases, to safeguard the interest of the company, any member or members may bring an action in the name of the company. This was recognized in Foss versus Harbottle. This can be well illustrated by the decision of the Ontario High Court in Glass versus Hutkin, 1967, 65, DLR 2D 501, wherein a company was controlled equally by two defendants and two plaintiffs. The two plaintiffs brought an action against the two defendants, alleging that they had fraudulently converted the company's assets for their own personal use. Allowing the action, the court held that though the action against the defendants ought to have been brought by the company itself, but in this case it was appropriate for the two plaintiffs to bring an action on behalf of the company, since the control of the company lay in the hands of two defendants who would prevent the company from action being taken against them. In Wallstrainer versus Moyer, 1975, All ER 849, Court of Appeal, it was held that where wrongdoers themselves control the company, an action can be brought on behalf of the company, the minority shareholders, on the footing that they are its representatives to obtain redress on its behalf. So, if wrongdoers to the company are in control of the company, they will certainly not allow the company to file an action against such wrongdoers. In such cases, minority can act. In Spectrum Technologies USA Inc. versus Spectrum Power Generation Company Limited, 2002, 48 CLA, Delhi High Court, it was held that minority shareholders themselves can bring an action in their own names against the wrongdoing directors for the damage done by them to the company. Fraud on the minority, where the majority of a company's members use their power to defraud or oppress the minority, the court will interfere at the instance of minority. Take a case, for instance, where the directors decide upon a course of action which is advantageous to themselves but injurious to the company. A suit by a minority in such a case as champions of the company's interest would lie. In Meanier v. Hoopers, Telegraph Works Limited, 1874, Law Reports 9, Chancery 350, the majority of the members of a company A were also members of the company B. At a meeting of the company A, they passed a resolution to compromise an action against company B in a manner alleged to be favorable to company B but unfavorable to company A. Held, the minority shareholders of company A could bring an action to have the compromise set aside. It was observed that it would be shocking thing if the majority of shareholders are allowed to put something into their pockets at the expense of the minority, where the act done is illegal or ultra vires. Every shareholder has a right by injunction to restrain the company from doing any acts which are ultra vires the company or illegal. These acts cannot be adopted even by unanimous vote of the shareholders. Where the act can only be done by a special resolution, but in fact has been done by a simple majority by passing only an ordinary resolution. In such a case, any member can bring an action and get injunction restraining the majority. Where the personal rights of an individual members have been infringed. Every shareholder has certain rights against the company. Some of these rights have been conferred by the Companies Act itself. Some arise out of the articles or general law. If any such rights is in question, a single shareholder can defy a majority. Oppression and mismanagement. The principle contained in section 241 of the Companies Act 2013, which relates to prevention of oppression and mismanagement in a company, is also one of the exceptions to the rule in Foss v. Harbottle. Prevention of oppression. Who can apply? According to section 224 of the Act, whenever the affairs of a company are being conducted in a manner oppressive to any member or members or prejudicial to public interest, an application can be made to the tribunal under section 241. According to section 244 of the Act, where the company is with a share capital, the application must be signed by at least 100 members of the company or by 1/10 of the total number of its members, whichever is less, or by any member or members holding 1/10 of the issued capital of the company. If the company is without share capital, the application has to be signed by 1/5 of the total number of its members. Joint holders are considered as one member. However, the tribunal may, on application, allow any member or members which makes it just and equitable to do so. Once the consent of the requisite number is obtained, the application may be made by one or more of them on behalf of and for the benefit of all of them. According to Section 241, Subsection 2 of the Act, the central government also has the power to apply for relief under this section. In Efficient Publicities Private Limited Re. 1989, 1 Company Law Journal 208 Company Law Board, it was held that the tribunal also has the discretionary power to permit a lesser number of members to proceed under the section. In Kelly and Henderson Private Limited Re. 1980, 50 Company Cases 646 Bombay, it was held that once entertained, a petition under this section can be compromised or withdrawn only with the sanction of the tribunal. Conditions for relief. The grounds on which an application can be made under Section 241 are: A. That the affairs of the company are being conducted in a manner prejudicial or oppressive to a member or some members, or in a manner which is prejudicial to the public interest, or in a manner prejudicial to the interest of the company. B. A material change has taken place in the management or control of the company, whether by an alteration in the board of directors or manager, or in the ownership of the company shares or its membership, or in any other manner whatsoever, and that by reason of such change it is likely that the affairs of the company will be conducted in a manner prejudicial to its interests or its members or any class of members. If an oppression of this kind is established, the tribunal will, with a view to bringing to an end the matters complained of, makes such an order as it thinks fit. The meaning of the term oppression, as explained by Lord Cooper in the Scottish case of Elder versus Elder and Watson Limited, 1952, SC 49, Scotland, was cited with approval by Justice Vanchu of the Supreme Court of India in Shanti Prasad Jain versus Kalinga Tubes Limited, 1965, 1 Company Law Journal, page 193. The essence of the matter seems to be that the conduct complained of should at the lowest involve a visible departure from the standards of fair dealing and a violation of the conditions of fair play on which every shareholder who entrusts his money to the company is entitled to rely. The complaining shareholder must be under a burden which is unjust or harsh or tyrannical. Oppression of majority. In Baltic Real Estate Limited Re. 1993, BCLC 498 Chancery Division, it was held that it should not, however, be supposed that these special remedies against oppression or mismanagement are available only to minorities. In appropriate case, if the court is satisfied about the act of oppression or mismanagement, relief can be granted even if the application is made by a majority who has been rendered completely ineffective by the wrongful act of a minority group. A petition is not liable to be struck out as showing no reasonable cause of action just only because it is filed by majority shareholder. The complaining member must show that he is suffering from oppression in his capacity as member and not in any other capacity. In Hanuman Prasad Bagri versus Bagras Cereals Private Limited, 2001, 4 SEC 420, it was held that the facts alleged in the petition must justify a winding up order under the just and equitable clause of Section 271 of the Act. The facts alleged must reveal an oppression of a continuing nature. Isolated acts of oppression will not do. There should be fairness in the conduct of the petitioner. Prevention of mismanagement. Section 241, Subsection 1, Clause B of the Act provides for relief in cases of mismanagement. For a petition under this section to succeed, it must be established that the affairs of the company are being conducted in a manner prejudicial to the interest of the company or public interest, or that by reason of any change in the management or control of the company, it is likely that the affairs of the company will be conducted in that manner. If the tribunal is so convinced, it may, with a view to bringing to an end or preventing the matter complained of or apprehended, make such order as it thinks fit. Powers of the tribunal. Powers of the tribunal under Section 241 and 242 are fairly wide. In fact, the tribunal may make any order for the regulation of the conduct of the company's affairs upon such terms and conditions as it may think fit. Apparently, the only limitation seems to be the overall objective of the sections, and therefore the order must be directed to bringing to an end the matters complained. After hearing the lesson, the viewer will come to know the rights of the minority members against the majority in case they act in a manner oppressive to any minority members. He will also know the remedies available to the members of the company in case the affairs of the company are mismanaged. I hope you enjoyed this session, and we will meet in the next session. Thank you one and all.